Lawyers pushed for the conclusion of election petitions before the inauguration of elected president, governors, and lawmakers in the future. The lawyers said this will ensure the sanctity of the electoral process, decrying a situation where the courts decide leaders of the country as against through the votes of the electorates. Joining us now to discuss the theme of the conference, Post-Election Nigeria, the judiciary in the eye of the storm, and how it relates to our everyday discourse, is Uju Agomo, Chair, Content Subcommittee of the Conference Planning Committee, CPC, 2023 Nigerian Bar Association Section on Public Interest and Development Law, SPIDEL, and Oke Ohagba, Chairman, Conference Planning Committee 2023, Nigerian Bar Association Section on Public Interest and Development Law. Good morning and welcome to the morning show.
Good morning.
Well, thank you for joining us, Dr.
Yeah. Thank you.
Pleasure.
Thank you also, Oke Ohagba, for joining us. Well, quickly, to set the tone for the conversation, the judiciary in the eye of the storm. This is the third day of the conference. Closing later today. But what are those emerging issues around the theme, from the contributions in the various sessions? What are those key emerging issues that you think Nigerians should pay close attention to?
Thank you very much, Ruben. I think part of the issues that came out very clearly is that, one, it's not just about talking about the judiciary, that we also need to talk about the bar, the lawyers that are the bar, the lawyers practicing. But it's not just about the lawyers, it's also looking about the executive. What is the role of the executive? What is the role of the legislature? So it becomes very clear that we must do everything possible to ensure that the judiciary acts right. But in doing that, there are roles for each and every one of us. That was part of some of the things that came out clearly. There were also discussions, when sometimes you say the last hope of the common man is what? The court. It was shocking to hear clearly that it is not the last hope. That we should not think that the last hope it's the judiciary. Because if the judiciary doesn't do the right thing, you'll be shocked what will come after. And for the preservation of everything we all believe in, we must try to act right. Because if you don't act right, you are pushing the public, you are pushing the people, and they will rise up someday. That's something for us to know. And we also talked about issues about independence of the judiciary. Yeah. They have to be comfortable. Issues about integrity, about trust. So we can't play with this whole subject matter.
Yes. All right, Mr. Ohagba, I'll come to you for the next question with regards to the conversation around petition tribunal timing. Mr. Olisagbako by SAN had come on the show and talked about the fact that perhaps going forward, the cycle for election petitions should all be concluded before the swearing in of the president. What was the conversation around? What's your take? What's the position perhaps from the conference on this matter?
Yes, thank you very much. It's actually, there is need to retool our electoral process. The act, and we need to start from the act itself, because all that will be had to be put into the act, so we can have a system that will be fair to all. I think I agree with past President Abakoba on the need for it will create for more sanity in the system, where we conclude all issues arising from the election before swearing in. But that we need to go back to the Electoral Act and fine-tune it more. You see, the theme of this conference is deliberate also, and in the sense that the elections have come and gone. The task is now before the judiciary. We at SPIDEL as an advocacy group is putting the judiciary on their toes and reminding them of the need to do the right thing. That Nigerians out there are watching and waiting to see that the right things are done. And when the right things are done, and the right things being done in the general of it includes also the need to retool the Electoral Act also in future elections. Let us conclude issues arising from the elections before swearing in of the candidates.
All right, so I have a quick question for both of you. I'll come to you first, ma'am. Number one will be about the Bokachua issue. After the revelation made at the valedictory service of the House, she's come out to say she did nothing of such. But people are looking and saying, it's not just by a rebuttal that we did something. What's the investigation even into the cases or cases handled by her in the past to be able to look at this matter critically? Yeah. Because that's a big indictment, you know, on our judiciary. And it is sad, and I'm sure issues like that, people just look at it. And you see, because what we fail to realize is decay comes systematically. The decadence in our society today didn't happen 5 years ago, didn't happen 10 years ago. It happened over 20, 30 years ago. And when people see this, they form their opinions. But it is also when people see justice that it can hither to shift that confirmation bias they have. Yeah. So the confirmation bias now as regards the judiciary is that it's not the hope of the common man any longer. I mean, what's your take about this Bokachua case? I'll ask you first and I'll come to you, sir, afterwards. Yeah.
Thank you. Thank you. Indeed. You know, I always like to look at issues from a holistic perspective. So I think it needs to trigger first an independent evaluation and assessment of everything she has sat to judge. But it's not just about her. Think about it. If somebody didn't make a confession or didn't say, would you be doing this? So why don't you see this as opening the box? Why don't you see this as putting checks and balances where there need to be constant review, not only about judicial judgment, but also administrative decision-making processes? It is important because the truth of the matter is this. You know, you can tell people do something that is right. The only incentive they can have to do those things right, why? Listen, it's when they know that if they don't do it right, they'll be caught. So it's the same way when you say to people, if you violate this particular offense, this is your sanction. But when there is no certainty of the fact that you'll be caught, certainty of the fact that when you are caught, you'll be prosecuted, certainty of the fact that when you are prosecuted, you'll be found guilty if truly you were guilty, certainty of the fact that you will be sanctioned and you will serve that sanction. So that's the point. So people think they can do anything and get away with it. The concept of impunity. So I hereby say that it's not just about her. We do it for her, but we do it for all the log. We do it and make sure we put in place clear systems that will make sure there are checks and balances, and that no matter what you do, we'll come back to it. And that would then deter people. And I believe that we should not trivialize this. As you said, it's right.
No, NGC has not even said, let's review the cases.
That was said. I mean, I think this was also part of the issue that came up at the conference.
NGC has not said anything.
We need NGC to speak. We need this to be done. So, you are right. But I also like the point you made that this is an incremental process. And for God's sake, we really need to make sure that we shield the judiciary from this bastard act of everybody kicking, everybody. You know, when we pull it down, you know, it's not just this incident. I'm sure you also heard where somebody was asked, how come? What was it that you did? How come you're here? Yeah. And he said, how? The court. Yeah. That is also another
yes.
So I think that
was to the Senate president. The question Rochas Okorocha asked is, how did you get here? And we all remember those two judgments. One with the incumbent Senate president, another one with Ahmed Lawan, the former Senate president. You know what pains me? Listen, it's because if only we can understand that we are not doing another, but we're doing ourselves. If only we can understand that, you see, part of what happens is just like when you see somebody being carried to be, buried. You may not care about it, but that person is somebody's family, and tomorrow it can be you.
So again, I want to use this platform to plead for God's sake that we should save the soul of this nation. We're not doing it. So I agree, it is incremental, but we must do something. At a point, we must say, no, we can't continue this way.
Sir, how about you, sir?
The image of the judiciary is at its lowest ebb at the moment in the country. And some people call the comment by Senator Bukashua, some people call it a careless slip. But I see it as a confession. It's a confession, and it is a call. Maybe it's an avenue for the judiciary to sit itself up. The NJC has a task on its hand, and I believe in actions. In this case, the NJC's silence can never be golden. I think the NJC immediately needs to swing into action in this particular instance. Set up a committee, review all past judgments of my lord, and be sure that the right things are done. You see, we must take action in all cases. The moment we will start taking actions, that is when Nigerians can see that, yes, the judiciary is doing the right thing. In this particular instance, the NJC must take action, and Nigerians are waiting to see the action the NJC is going to take on it. Thank you.
Okay, Chairman, I will come to you, and then I have a question for you also, Doctor. Now, one of the issues at the conference is about ethics in the Temple of Justice. So, Chairman, maybe you want to start with that and address the subject, judges abusing expert emotions, lawyers bringing frivolous and vexatious matters and wasting the time of court and all that. What can be done about ethics? And when Chairman is done, I noticed that Section 6 is about administration of justice, particularly Section 12 of the Nigerian Correctional Service Act. And you are here. You are the #1 prison reform activist in Nigeria. I want you to help us link, the two in terms of custodial centers and administration of justice. Chairman, you go first.
Thank you very much. There is a way forward already. The rules of professional conduct has just been repealed, and that is for ethical conduct of lawyers. I believe that is being taken very seriously by the NBA President YC Michael SAN. On the part of the judges, I believe that there is this generalization that all judges are corrupt. I don't believe that. There are good judges. There are ones who are not corrupt. So I believe that the judiciary, which the NJC is the body who sanctions, who makes laws, and who oversees the actions of these judges, must set in motion reforms to see to ensure that the corrupt ones, or find a way of rehabilitating, if I use that language, overhauling the judiciary to see that issues of corruptions are dealt with. The bar on its part, with the new RPC, I believe the bar will take ethical cases very seriously. So I think with that, the issues of ethical values in the Temple of Justice will be seriously dealt with. Thank you.
Okay, Dr. Gomo. The emphasis on Section 12 of the
Nigerian Correctional Service Act. Okay.
2019.
Yeah, thank you very much, Ruben. Yes, when you go to Section 12, subsection 4 to 12 of the Nigerian Correctional Service Act of 2019, there were very critical things that were done by that section. And clearly what that section was trying to do was to kind of align itself to the provision of Section 2, subsection 1 of the Act, which states about the objectives. So if you look at that Section 2, sub 1, it talks about, 1, the need to align the practices in Nigeria with correctional best practices and international human rights standards. The second, talking about the effective implementation of non-custodial by providing that platform. The third, talking about the notion of reformation, rehabilitation, and reintegration. And the fourth, and this fourth is very important, talking about establishing a systemic and institutionalized and sustainable mechanism to deal with the high number of persons who have been convicted, the pre-trial persons. So when you go to that section 12, subsection 4 down, it provided an early warning signal. Because you and I know that the biggest problem that the Nigerian Correctional Service is having has to do with overcrowding. And it's not overcrowding in all the 244 centers. No. It is overcrowding, especially in the cosmopolitan areas. So all the facilities that you have in the cosmopolitan areas, most of them are overstretched. And by the time you have high number, close to 70%, that you have not been convicted. And many of them stay higher number of time to be there. Then the whole notion of getting more criminalized becomes there. So section 12, what it says in subsection 4, it says whenever the facility, the correctional center, is being about to be overcrowded, because each center has a designated population. So it says that the officer in charge, the superintendent in charge of that facility, or the state controller should set the real alarm and then inform the chief judge, prerogative of mercy, and the rest of them, okay? And including the justice sector reform and all that. But when you inform that you have 3 months, that 3 months enables this whole mechanism to be able to do something to reduce that population. And there are a lot of reasons, not only about money, but expenses on the government and the rest. But so if they don't, within 3 months, do something to reduce that number, then the correctional service should say no, they should not take. And the reason for this is to bring a check and balance. And if they continue, then it should be sanctionable. So the whole notion, and this is really important, because when you talk about checks and balances, that the fact that there are persons who get to be in custody for not just cause. You have people who are innocent, you have people who are minor offenders, sometimes staying longer than they could. So that is really a functional section to help us deal with the provision of subsection D of sub 2(1). So section 2, sub 1D is the actual way of activating it. It's provided very handsomely for us under section 12, sub 4 to 12. But the question is, are we implementing it? Which is where the problem is. Because if you don't, it's just like when you look at the Administration of Criminal Justice Act of 2015, section 34 talks about how the judiciary magistrate should go and monitor places of detention like the police stations. So we need to implement these laws. That's the problem. We're not doing it.
All right, let me ask, this question is to both of you. Now, last year at the NBA conference, and I'm bringing it again here this year because it doesn't seem like a lot has changed. And then it begs the question as to, when we have conversations like that, you talk about implementation just now, how do we carry the conversation forward beyond just coming together to speak about this? You, alongside some other lawyers, had spoken to perhaps preferring solutions to undermining of judges in Nigeria. One of the things you had spoken about, one of the submissions was number one, which has been said a number of times, the separation of offices, Attorney General of the Federation, Ministry of Justice. You also spoke about the independence of the judiciary, particularly in terms of remuneration. And there was a statement around politicians being on the neck of judges, preventing them from actually delivering judgment or sound judgment. I don't think a lot has changed in 1 year since the last conference. Now that we have a new tenure, a new president, are you hopeful? And if there are other things, and this question is for both of you, in terms of strengthening the judiciary, because we can complain about the fact that, we don't have confidence in the judiciary, it's no longer the last hope of the common man, but there are also issues that have to be addressed in terms of not undermining the judiciary in Nigeria.
I like the way you ask this question, because it's almost like saying, we're talking. When can we start acting? When can we really start making a difference? And that's why I like it. So, yes, you're correct. There's a lot that has said needed to be done, but it haven't been done. So the question is, do we then do nothing because the ones we said we should do something about we have not done? My response would be no. So we will keep pushing. But again, I really feel very convinced that there is a critical problem. I will say, and I was just discussing with somebody a while ago about the same issue. I will say the technical word and I break it down. I think this is at the heart of the bulk of the problems that we have. It is a lack of conscientization, and let me explain what I mean by that. A lot of times we talk about there are problems. Oftentimes I ask, truly, do we really know the root causes of our problems? Because we need to. It's not symptomatic things. We can't just be talking about only the symptoms. We really need to dive deeper to understand what is causing what. Till we get to that root cause, that's number one. The second level, we need to also articulate the solutions that will make the clear impact. Again, not symptoms. It's like when you have malaria, it's just not just by taking the medicine or that thing. You need to deal with what is causing you malaria. So we need to deal with the solution. Now, the third leg is a big issue. What is that third leg? The fact that when you identify the solution, you put yourself as part of that solution. So this is where I come to respond to that question. So they are not responding. There are a lot of things that are not working well. We need to be able to now look at how we cluster those solutions in terms of who need to do what. And then if they don't do it, who need to do what to either name and shame, or to push or to do anything else to get it to done. It's like knowing that they will make decisions, they will make policies, they will make laws that truly represent the public interest, and that's the problem.
Oh, okay. Mr. Ohagba, your take on this.
Thank you very much. You see, I once wrote an article that titled "Tackling Judiciary on Independence in Nigeria." Because I don't think we have an independence of the judiciary yet. We are playing lip service to that as far as I'm concerned. And that's a view I hold very strongly. What we have in Nigeria is judiciary on independence. Because if we want to ensure independence, true independence of the judiciary, we must look at the foundation. We must look at the foundation, the appointment, the root of it. Who appoints who? Provided the governor of the state still has powers to appoint the chief judge of the state. Provided that the president of the country still appoints the CJN. There is a thin line. There is where you can separate that independence truly. So there's a whole lot needs to be looked at on the appointment process. I think the NJC has a lot on its hand to look at on reforming the judiciary. When you reform the judiciary, that is when you can now have a total independence. Because when you bring those reforms, it will critically touch on the appointment process. By the time we get it right, then we'll be sure that when you talk about true independence of the judiciary, everybody will see that